Good morning, everybody, and welcome to today's webinar. We'll just give it like just 2 more minutes before we can start. Okay, welcome everybody again to today's webinar and happy Friday. So today we'll be talking about the future-proofing the water sector, and most likely we'll be looking at risk management, compliance, and resilient decision-making. My name is Mapari. I'm a civil engineer, and I also have experience in the water sector. And I also have my MPhil in water engineering. I'm a certified Autodesk instructor and also an ISO 19650 practitioner. So in case you're new, just to give you a brief information about Baker Baines, who we are and what we do. We have 3 core things that we specialize in. The first being consulting. We do mostly people, process, and business assessment. We do a lot of BIM consulting, data management, CAD/CAM. And the second one that we have is education, meaning we do a lot of training, which is accredited. We do both classroom and also virtual training. We also have customized user or project-based training, meaning if you have a nice project or complicated project that you're working with, you can always come to us and we'll actually help you with that. We also have self-paced e-learning platform. We use Pinnacle series for that, meaning you can learn at your own time, on your own pace, and all our courses are accredited. And the third one is software and hardware. We are gold partners with Autodesk. We partnered with Leica and also ClearEdge, and we do all these things for energy, civil, process plant, manufacturing, and also even building. So I'm going to start with the poll, which my colleague will launch it for you. So the poll is just for us to get to know you better about your role in the industry. If you're like an engineer, you're a contractor, maybe facility manager or owner, you're an architecture, maybe director. And if you're like anything or your role is something that's not specified, you can even like type it in the chat box. So we just wanna get to engage with you and get to know you better. So I'll give it a minute just for you to do the poll, but we'll just like keep it running for some time just to know who we have in this platform right now. Okay, just a few more minutes. Okay, so your poll, your primary role, what do you do in the industry? Are you an engineer? Are you a contractor? Are you a director? Are you an owner or facility manager or architecture or other? Because this webinar is just for you, so you're at the right place. Okay. I see I see most people, which is like 35% that we have in this webinar, they're like engineers, and we also have 15% which are like directors, and we also have 43% that is other. We don't have any architecture, and we have 4% of contractors. So we'll just keep it open for now, but we have a lot of engineers in the room, and everybody else, you're still welcome because you'll really learn a lot from today's webinar. So let's start with the reason we're all here today, which are challenges that we're facing most in water industry. So we have challenges that are due to climate change, population growth, and even aging infrastructure. And we all know today that with the rising climate change or the rising temperature, some people call them volatile, because we have a lot of change in precipitation patterns. And when it comes to population growth, when you drive, let's say everywhere in Joburg, the new developments, and it means our population is growing every day. And meaning when the population is growing, it means the demand also increase because of that. And that will strain maybe the existing water infrastructure. And now when we plan for future, we also need to accommodate the population growth so that everybody can have access to potable water. And with our aging infrastructure, when we look at it, most of our systems are outdated and they require modernization so that they can keep up with the increased demand and also environmental challenges. So they need to be more resilient. And that's why we're talking about how do we then future-proof the water sector, looking at all these challenges and components that I've been mentioning. So increasing rainfall, we all know is due to climate change. And now we need to set up regulatory requirements for things like your peak flow control, detention designs as well. And we also need to be at a point where we can deliver accurate documentation for permitting and also even during construction, and also make sure that all our designs, all our models and everything, they actually integrate well with the terrain that we have, the hydrology, and even the infrastructure models that we'll be designing or working with. So we need to have the entire value chain for that, where we have where we can cover the whole water life cycle, like your project, from a single drop of water and until the asset life cycle, covering from planning, design, build, and also operations and maintenance. And when we look at that, we look at the transformation for our water structures, our water and wastewater treatment, our sewer networks, drainage systems, water distribution, and also stormwater and floods. And remember, for all this, we look at it from planning point of view until operations and maintenance. And we also look at the products that we have in the water, in the authorized water solutions, which capture the whole entire chain, meaning these are for all these 6 pillars that we mentioned: the drainage, the water distribution, your water treatment plant, asset management, storm, sewer, floods, all of that. So the product that are shown in the slides will also show you how can we solve these challenges that we're having in this industry that always have these changes, these challenges, and everything else. So we look at drainage systems. I would mostly likely talk about info drainage because it helps with your design optimization. And when it comes to your storm, your sewer, your floods, that would be your InfoWorks ICM. And with your water distribution, where you model your water distribution systems, just to make sure that they ensure and they meet the service levels and even the delivering clean potable water to people, and that would be your InfoWater Pro, InfoWorks WS Pro. And now when you go to operation and maintenance, that's where we look at the Info360 asset, and also the Info360 Insight, and even the Info360 Plank for your waste water operations and optimizing the system as well. So there are a lot of incident warnings, decision support systems, which would help us. I know some people already are using, let's say, AI just to predict where and when pipes or mains are likely to break, but we also have solutions for that. And due to the population growth that we see and the historical consumption rates that we are aware of, and even the weather patterns that we see every day, and even the land use changes. So we need to have things in place where we can actually be able to predict all these future water shortages, because they'll also help us plan better and also avoid having like burst, and even to optimize our pumps to make sure that they actually run efficiently. So just think about yourself, right? Let's say you're taking a walk or you went for a hiking and you're thirsty, and then you see like a river, there is water. Are you just going to drink that water? So this is what we call problem prediction. So in my case, if I was passing by, I would almost certainly predict that the water is not safe. I won't drink it without treating it first. That's why maybe you need to boil it, you need to maybe put some disinfectant in it, but just drinking it, you just predict and assume that, okay, although it looks crystal clear, it looks like it's clean and is maybe moving very fast, or it's just like a natural water source, you know that it's never 100% to consume, and you won't just drink it, because it means you'll be able to even predict problems before they can happen. Then we talk about also incident detection, things like having your best pipes. Once you have that, it means your customers will be affected. If your water quality is contaminated, meaning the source of that contaminity, you have to deal with it. And we also know that if your water is contaminated, it also affects or plays a role on your downstream supply, right? So these are all the things that we'll be looking at and discussing all these things, and looking at the risks as well, and having things like pipe failures, having to maintain service levels, your network resilience, and also even predicting the water quality and everything, and making sure that you don't have any leakage, burst, or issues, everything that can put your water assets or infrastructure at risk, or even people at risk. So we have all these Autodesk water solutions for you that can actually help you to prevent all those problems. And today we're going to talk about just waterproofing our future water systems. So as we'll be diving into the topic, which is future-proofing the water sector, most will be talking about risk management, compliance, and even resilient decision-making, which is crucial for us right now in our country, and I'd say globally, but I'll just say in our country. So given all those challenges that we mentioned, all the problems, incidents that they can okay, please allow me to introduce you to our special guest speaker, who is an expert in this field. And let's welcome Matthew Bennell, who is the founder and principal attorney at Bennell Attorneys, a South African law firm specializing in environmental and natural resource law. He is recognized in the Chamber's Global Guide as a leading practitioner in environmental law, and Matthew has extensive extensive experience in like assisting clients across sectors such as mining, infrastructure, agriculture, and even energy. So with legal issues spanning the full life cycle of environmental regulatory processes from licensing, compliance, administrative appeals, and even the judicial reviews. And in the water sector, Matthew has advised clients on the pumping, the treatment of extraneous and polluted water, wastewater management and disposal, and climate change impacts and risk arising for deficient and surplus water supply. So welcome, Matthew. I'll be handing over to you now and looking forward to learn from you. You?
Thanks, Papari. Good morning, everyone. I will quickly share my screen and some slides. So just give me a moment. Let me know if you can all see it. Great, thank you so much. And good morning, everyone. It's a real pleasure to be able to have this discussion on water. And I think it's really important given that it's World Water Day on Sunday. So the timing of this presentation couldn't really be any better. Since I started practicing law almost 20 years ago, the primary point of focus in respect of water-related matters was on permitting. That is, did the company have a water use license to undertake its water uses? For those of you involved in permitting processes, this question is not always easily answered because water users could continue water uses without a water use license under the National Water Act if it was conducting a lawful water use for the 2 years prior to the Act coming into effect. To determine if this was the case involved validation and verification and registration processes, which as time has gone on has made it a little bit more difficult to determine whether or not these uses are lawful because they, because the information or the data behind it is not always readily available. Since then, at that time, the primary disputes were about the license itself, the granting of the water use licenses, and generally the processes and the department's delays in issuing licenses. For a large period of time, the Water Tribunal, which is the body that's responsible for hearing appeals on water matters, was defunct and not operational. I think today things are very different. I would say that about 40% of the work that we do is related to water, either in the form of disputes, commercial matters such as water supply agreements, or M&A transactions regarding water security. Many of the water disputes tend to relate to matters of there being too much water and how this water needs to be managed and who is responsible for managing this water. This has become particularly pertinent because climate change is changing weather patterns and resulting in more extreme and intense weather events, resulting in higher than average rainfall in some areas and more intense storms. And the frequency of these storms has also increased. Existing infrastructure is not in many cases, or was not in many cases, designed to cater for these changes. As a result, investment into this infrastructure and predicting water volumes and flows to inform such investment has become an essential criteria. This is particularly important in respect of infrastructure responsible for treating wastewater and water containing waste, which are being overwhelmed by the significant increase in throughput through those facilities. On the commercial side, water supply agreements and securing water supply in drier areas, which are only expected to get more dry due to climate change, is more common. And in M&A transactions, the resilience of infrastructure to withstand or cater for these changes in the environment, either to manage instances of there being too much water or adopting water efficiency or closed water system technologies to reduce reliance on water needs. As you can hear, we can talk about this topic all day. As a result, to try and focus on all the issues is impossible for this presentation. As a result, we're not going to discuss the minute details of legal compliance relating to water issues under the relevant legislation. If you have any specific questions, please feel free to reach out to us. Alternatively, ask your questions in the Q&A box, and we will try and answer those at the end of this session. There is a lot of information around compliance. The general principles, however, governing water law are that water must be used efficiently, clean and dirty water must be kept separately, and water must be used lawfully, i.e. in compliance with water use license conditions, standards, and similar guidelines. Modeling water volumes and flows is critical to achieving these objectives, as it informs decisions on infrastructure investment to not only achieve legal compliance, but also ensure business continuity. Just a quick agenda of what we're going to discuss today. I'm going to just have a few disclaimers that I must make up front. As I'm a lawyer, we can't do anything without some form of disclaimer. So please bear with me with those. Then we'll touch on some impacts of climate change and on water and businesses. We'll then discuss environmental liabilities arising from the failure to appreciate extreme weather events on water volumes and infrastructure. We'll touch on supply chain risks and climate proofing the supply chain in contracts. And we'll briefly discuss director liability arising from the failure to protect the company against flooding and drought risks. And then we'll touch on the Q&A. So as I said, disclaimers. We've prepared this presentation merely for information purposes. Obviously, you cannot and should not use it as legal advice. And if you do have any queries which are specific around the duty of care or liability, we recommend reaching out to legal counsel to guide you appropriately based on the facts of that case. The second disclaimer is really just around the examples that are provided in this presentation. The examples are taken from the media. They are merely used as examples to demonstrate the effects that flooding in particular can have on the environment. We do not know what measures were taken by the companies that are used in these examples and whether or not the measures that they took were adequate or inadequate. We are only providing these examples just to show the impact that flooding can have on the environment. Right. So talking about the impacts of climate change, the World Economic Forum's Global Risk Report for this year ranks extreme weather events as the third current global risk behind geoeconomic confrontation and state-based armed conflict. Given what's going on in the world at the moment, I think this seems to be appropriate. Over the longer term, there are 5 environmental risks in the top 10, which were predicted by the World Economic Forum, with extreme weather events being ranked as number 1. Extreme weather events in these circumstances groups together various events which may not only be linked to water-related events like flooding and extreme rainfall, but might also include droughts and extreme heat conditions. These extreme weather events are becoming more intense and more frequent. The report also notes that legacy infrastructure that was constructed at the time when climate events were not as severe or regular may be at risk of failure, if not maintained, restored, or enhanced. Economic losses from natural disasters are also steadily rising. This graph is also taken from the World Economic Forum's Global Risk Report. The blue line represents annual economic losses in $1 billion, and the black line indicates the 5-year moving average of these losses. In the period from 2004 to 2024, i.e. a 20-year period, the 5-year moving average total economic loss has doubled from approximately $120 billion to approximately $245 billion. These figures have been adjusted for inflation, and so the figures are in real terms and not merely the distinction or the doubling is not due to inflation alone. High impact extreme weather events can cause severe and lasting disruptions to critical infrastructure, supply chains, employee safety, and transport needs. Despite this, measures to understand and mitigate these risks are often delayed to seemingly more urgent demands on budgets in both the private and public sector. According to Nedbank, African countries lose approximately 2 to 5% of their annual GDP to climate disasters and spend 9% of their annual budgets in responding to climate change emergencies. This demonstrates a reactive approach to climate change impact mitigation rather than a proactive approach to minimizing or eliminating impacts. As the number of and intensity of extreme weather events is likely to continue, so too will the scale of direct critical investment impacts. The knock-on economic and societal risks are also likely to increase. This could be catastrophic if extreme weather events cause a failure of utility services such as the provision of water or electricity or impact on food security. There are several benefits to implementing mitigation measures sooner. The costs of implementing these measures is only going to increase, so mitigating them sooner is going to be better from a cost perspective. Mitigating measures reduce the likelihood of infrastructure failure or minimize the extent of such failure. Limiting or reducing business interruption risk if you implement these measures sooner, limiting or reducing risks to employees' health and safety. Also, limiting or reducing the risk to the environment and the costs of rehabilitation and or reducing your prosecution or legal non-compliance risk. Closer to home, in a recent paper published in the Environmental Development Journal, the authors documented extreme weather events for the period of 1980 to 2023 in South Africa. These events were selected based on the International Emergency Events Database, which was launched by the Center for Research on the Epidemiology of Disasters. In order for a weather event to be reflected in this study, one of the following criteria had to be met. There either had to be a death of 10 or more people, 100 or more people had to be affected, a declaration of a state of emergency had to have arisen, or there had to have been a call for international assistance. These criteria set a relatively high bar before the weather event is recognized as being significant, and thus underrepresents the extreme weather events that may have more localized impacts or impacts on a business. Notwithstanding this, the graph is interesting for the following reasons. During the period of 1980 to 2023, flood-related incidents, so those are that's the river exceeding its banks or flash floods, were the most common extreme weather event, followed by storm events, which obviously is associated with flooding as well, and drought, another water-related impact. On this graph, the floods are represented by the black bars, storms by the pink bars, and droughts by the dark red bars. As you'll see towards the end, particularly from 2020, there is a lot of flooding risk and extreme storms. In 2022, there was a doubling in the record number of reported flood disasters with 8 incidents, illustrating that the frequency and intensity of flood events is increasing. 4 flood disasters were recorded in 2019 and 2023, and 3 occurrences in 2000. This indicates that the record number of flooding events were reported in the last 5 years, with every year in this period reporting at least 1 flood disaster. 2 events were reported in 1996, 1999, 2001, 2006, 2009, and 2016. Interestingly, up until 1996, the number of reported flooding incidents did not exceed 1. So if we look at the need to build resistance, the UN Secretary General stated in 2001 that the climate crisis poses enormous financial risk to investment managers, asset owners, and businesses. These risks should be measured, disclosed, and mitigated. Some of the recent examples include Valterra Platinum releasing a statement in February of last year, indicating that the Tumela mine had to be closed temporarily due to flooding and the risk to employees. Just over a month ago, IOL reported that flooded roads in Limpopo, KwaZulu-Natal, and in Mpumalanga resulted in billions of rands damage and over 100 lives lost. The report also listed a trend of recent flooding and resultant damage in South Africa. This shows that the number of extreme flooding events are more frequent. There were 3 years between the 2019 and 2022 events, and then 4 events in less than 5 years between 2022 and 2026. Some more examples. The Health and Safety International reported in November of 2025 that South African businesses need to prepare for flooding risks associated with the La Nina weather phenomenon. And just this week, Mining Review Africa reported that the South African Weather Service had issued several impact-based global warnings for the mining heartlands, stating that a yellow 2 level warning has been issued for disruptive rainfall, leading to localized flooding of roads, settlements, and low-lying bridges. This particularly affects the northeastern Mpumalanga and Limpopo. The African Sustainability Matters reported physical risks from extreme weather events such as flooding are projected to drive the majority of impacts on businesses, potentially costing the world's largest companies $1.2 trillion annually by 2050 under a moderate emissions scenario with no additional adaptation. They also reported or predicted that sectors like utilities, energy, and financial services face the heaviest burdens, with utilities alone potentially exposed to about $244 billion in aggregate annual costs by mid-century. Despite these escalating threats, ASM reports that many businesses remain unprepared. Only 35% of the companies it surveyed globally have developed context-specific climate adaptation plans that address physical risks through targeted measures. Adoption varies by sector, with utilities leading the way at 58%, with plans in place, followed by real estate at 50%. While sectors such as information technology, financial sector, and healthcare tend to lag behind at only 30% or less. This adaptation gap leaves companies vulnerable to business interruptions, asset damage, and supply chain breakdowns. ASM indicates that flooding and extreme rainfall have caused significant disruptions, including semiconductor shortages and airline losses exceeding $100 million in single events. The article also cites 2 examples. It notes that Danone in South Africa addressed water stress and energy disruptions with a microgrid and zero water discharge system, securing 100% processed water supply, cutting water bills by 30%, and avoiding production shutdowns worth billions. Unilever in Indonesia raised mill platforms and implemented bioswale drainage to protect palm oil supply from floods, reducing downtime by 70% and avoiding significant raw material losses. These cases show that adaptation investment can yield strong returns, including improved efficiency, reduced insurance premiums, and enhanced operational continuity, which can provide improved competitive advantages or market share where competitors in the market have not adopted similar measures. These examples demonstrate that implementing measures such as technology aimed at monitoring and predicting water management, leading to infrastructure development and resilience, is not just a cost, but a business sustainability requirement, and can even provide a competitive advantage. I've discussed the importance from a business perspective of why building resilience to climate change is important, but there's also a legal compliance component that is relevant. Here's another example. On the 26th of May 2022, the Business Day published an article about SAPREF's obligation to clean up pollution arising from a flooding event. In April 2022, the the torrential rainfall in KwaZulu-Natal caused severe flooding around Durban. The SAPREF refinery located south of Durban was flooded when heavy rains damaged the Umlaas Canal, allowing flood water to enter the site. Water levels reached approximately 2 to 3 meters across the refinery. As the flood waters entered, remaining operations units tripped offline and hydrocarbons were flared. Workers evacuated the building to higher ground, and some of them were rescued from the rooftops of the building by airlift teams. As I've mentioned in my disclaimers, I have no knowledge about the measures that SAPREF took to build climate resiliency within its operations. The reason for citing this example is to highlight the last 3 bullets on this slide, namely that hydrocarbons, debris, drums, and vehicles from oil recovery systems and waste dams were washed off site. Pollution spread to nearby coastal areas, affecting the coastline south of the canal up to the Tiger Rocks beach, and a large-scale environmental cleanup was required to remove contaminated debris from the beach, estuary, and mangroves. These bullet points highlight the failing to model and predict water flows and flooding risks can not only cause physical damages to business, but also result in environmental harm, which exposes the companies to significant rehabilitation and remediation costs. In addition, there are also other far-reaching liabilities, which I'll talk about shortly. Looking more closely at the legislation, we're dealing specifically here with Section 28 of the National Environmental Management Act. This act imposes a duty of care on persons to take reasonable measures to prevent pollution from occurring, continuing, or recurring, or where such pollution is authorized or inevitable, to minimize or rectify such pollution or degradation. There's a similar provision under the National Water Act, which largely duplicates this duty of care. Under the reasonable measures, to avoid liability under the duty of care, a person will need to demonstrate that they have taken the reasonable measures required of them in the circumstances. Reasonable measures in respect of flooding events may include modeling current and future extreme weather and flooding risks to operations and infrastructure and stormwater management, identifying potential environmental risks that may arise from a flooding event or infrastructure failure, identify measures to mitigate or prevent these impacts from arising, allocating budget and implementing measures to mitigate the risk, implementing early warning mechanisms, and remediating and rehabilitating the environment where pollution has occurred. The nature and extent of the reasonable measures depends on the person in question. For example, the reasonable measures required of SAPREF in the cited example would be different from, for example, the landowners on which SAPREF conducted its operations, assuming it's not the landowner, or SAPREF's lenders, assuming SAPREF has debt linked to its operations. While SAPREF, as the person in control of the operations, would have been responsible for assessing the risk of extreme weather events on its infrastructure, including flooding, and required to implement the reasonable measures aimed at preventing or mitigating this eventuality. It must be noted that only reasonable measures are required. That is, SAPREF was not required to prevent any impact from occurring. That is, it was not required to future-proof its business beyond what is reasonable, taking into consideration the risks and likelihood of extreme weather events, which we have shown is increasing, the age of the infrastructure, bearing in mind that older infrastructure maybe did not have the same design criteria that would cater for these extreme weather events, or C, the risks to the environment and third parties should a failure occur. For example, heavy industry storing dangerous or hazardous chemicals are likely to have more stringent responsible measures in place than perhaps a logistics company. And lastly, what the costs would be of implementing these measures. Whether or not the responsible person has taken the responsible measures, or the reasonable measures rather, in fulfilling their obligations under the section of the Act is important, particularly when we start looking at prosecution, which I'll talk about a little bit later. If a person hasn't complied with their reasonable measures required under the legislation, the competent authority can issue them with a directive instructing them to undertake specific measures by a particular date. Ordinarily, before these directives are issued, a notice of intention to issue a directive is issued to the relevant person, affording them an opportunity to provide representations as to why a final directive should not be issued. There are a couple of points to note here from a legal perspective. First of all, this opportunity to submit representations allows the recipient of the notice of intention to issue the directive to provide reasons why a final directive should not be issued. In doing so, you can set out the measures that you are taking and have taken to try and reduce or remove the risk from occurring, or the impact on the environment from occurring. You would rather do this and get the department on board with your proposed plan rather than allowing them to issue you with a directive which instructs you to take particular action that may not be aligned with what your business imperatives are, with your budgets, or with your proposed plans. So trying to get the department to foresee that you are taking things in hand may prevent a final directive from being issued and allow you to implement the plan that is, and in the time frame that is acceptable to the business. It's important to also note that you could, if a directive is issued, take that directive on appeal. However, unlike other appeals which would suspend that administrative decision, in this instance, a directive is not suspended unless you get a specific exemption. This means that you would have to implement the directive irrespective of whether or not you've lodged an appeal. If you fail to comply with the directive, then the competent authority can apply to court for a cost order to recover the monies from a host of other people who would have to contribute towards the costs of implementing those reasonable measures. These people include any person who is or was responsible for, or who directly or indirectly contributed to the pollution or degradation, or potential pollution or degradation. This includes companies whose infrastructure may impact the environment. For example, the company could be held responsible if proper water and drainage modeling is not done and or infrastructure was not implemented to suitably cater for these impacts, infrastructure was not adequately constructed to deal with these measures. The owner of the land could also be held responsible. Again, this is not looking at fault. So you don't need to have been the cause or the person responsible for causing the pollution or environmental degradation. You need only be the owner of the land in order to attract liability. To mitigate this liability, lessors must ensure that the lease agreements include obligations on the lessees to undertake risk assessments of the infrastructure against climate risk on a regular basis. They must implement reasonable measures to mitigate the risks of infrastructure failure due to extreme weather events, and they must include indemnities for any loss or harm suffered if an extreme weather event results in pollution or environmental degradation. Indemnity should be treated with caution, because if a court claims damages from a landowner under a duty of care, the landowner will be required to pay the monies to the competent authority and would only be able to reclaim that debt under the lease agreement, depending on the wording of the indemnity. If the lessee is insolvent or does not have sufficient assets to satisfy the landowner's claim, the landowner would not be able to recoup its full debt. As a result, there are other possible remedies that a landlord may want to consider, such as requiring a financial guarantee which can be called on in the event that there is a claim under the lease agreement. Alternatively, money is being held in escrow for such occurrences. Another alternative is to obtain climate-related insurance. However, this option is likely to become more expensive over time with increased risks of events and aging infrastructure. Insurers may also seek to invalidate claims where adequate maintenance, which could conceivably include updating your infrastructure to be more climate resilient, is not done. Of course, landowners can avoid liability under Section 28(8) if they can demonstrate that they took the reasonable measures that were required of them. These reasonable measures may include placing obligations in the lease agreement on the lessee to undertake climate risk assessments and to report compliance with these obligations to the lessor. The landlord may also want to undertake its own assessments and disclose these to the lessee, along with an obligation on the lessee to take the necessary actions to climate-proof the property. As successors entitled can also be held responsible, that successors entitled to the property can also be held responsible for the land. It is critical that proper due diligence investigations are conducted when purchasing property to understand the climate risks associated with the infrastructure, particularly where the infrastructure is old and has not been built with climate resilience in mind. The closer the property is to sensitive environments and persons, the greater the risk to environmental health and safety if a failure occurs. If this is the case, the greater the due diligence that is required in relation to the asset, and the duty to take reasonable measures is much larger. Persons in control of land, or any person to use the land when pollution or environmental degradation occurs, can also be held to contribute towards the costs. This may include a lessee or a sublessee. As with the case of the lessee must conduct proper due diligence and conduct technical assessment of risks arising from flood events and failing infrastructure. Where there are risks, lessees should push for the landlord to warrant that the infrastructure is climate resilient and indemnify the lessee in the event of liability. Alternatively, reduce rentals if the lessee assumes the responsibility of implementing the relevant climate resilience measures. It should be remembered that contractual terms such as warranties and indemnities cannot be used to contract out of these obligations. It merely provides a right of recourse against the lessor if the lessee is called upon to contribute towards the costs of implementing the reasonable measures by the competent authority. As I've mentioned, if the lessor does not have the necessary funds to extinguish the debt, the lessee may be out of pocket. Other persons that may exercise control over a property and therefore assume responsibility and liability include EPC contractors and O&M contractors. In respect of EPC contractors, the owner of the property or the infrastructure will want to ensure that the construction is climate resilient, bearing in mind that some of the current building standards may not have been updated to cater for climate events that are currently being experienced. O&M operators will also want to see warranties that infrastructure is climate resilient or a disclosure of potential risks so that these can be priced into the contract. Finally, persons who are negligent could also be held responsible, and over and above the category of persons that I've already mentioned. This might include directors, and I'll talk about that a little bit later, if these directors have failed to take adequate measures such as flood modeling or implementing measures to prevent environmental impacts from occurring. The competent authority can claim proportionally from these persons based on the degree to which they are responsible for the harm or the failure of the measures that they have taken. One point to also note is that in terms of Section 28(12) of the National Environmental Management Act, any person can notify the authority on 30 days to issue a directive or to take measures contemplated under the Act to prevent pollution or environmental degradation from occurring. And if they do not either issue a directive against that person or take such measures, you can approach court compelling them to do so. I quickly want to touch on incidents, because where the duty of care imposes an obligation for persons to act in a proactive way, incidents are more of in a reactive way. So this occurs where, for example, there is a flood event, and as a result of that immediate and unexpected event, there's contamination of the environment. So, for example, using our SAPRIF example again, there where there had been the hydrocarbons had been spilt into the environment, this spilling of a hazardous substance into the environment is what has ultimately caused the contamination, and measures need to be taken to immediately rectify that impact. What happens here is that there's obligations to notify the relevant authorities and to take measures to contain and remediate the environment. It also imposes obligations on persons to notify all those interested and affected parties that may be affected. Just quickly then on the offences, if you fail to comply with either a directive or with your duty of care in relation to to prevent pollution from occurring, recurring, or continuing, or failing to comply with the notification requirements that I've mentioned above, relating to incident provisions, you can be guilty of an offence and prosecuted. If successfully prosecuted, there are fines of up to 10 million rand and or 10 years imprisonment. In addition to that, the court prosecuting or considering the prosecution can also look at any damages that have been suffered by third parties and impose damages claims against the convicted individual for those damages. Those damage claims will be, although they will be issued under a criminal proceedings, will have the same effect as a civil damage, and you can claim that in the civil court, attach assets and sell them in execution to repay any damage suffered. In addition to that, the court can order any penalties that seem appropriate. So, for example, it could require the convicted person to conduct remediation or pay the costs of remediation. The costs of the prosecution can also be charged against the person convicted. And in instances where a company is found to have been guilty of the offences, there is a reverse onus provision on directors to avoid liability. This means that there's a de facto situation where a director would need to prove on a balance of probabilities that they should not be held responsible for the liabilities of the company. Reverse onus provisions are things that are quite controversial in South African legislation and South African law, and in many instances have been found to be unconstitutional. However, in probably the leading judgment on reverse onus provisions and director liability, it was found that where there is a case of a reverse onus provision for a regulatory offence, such as an environmental offence, the reverse onus provision, the constitutionality of a reverse onus provision may not be as reprehensible as in other situations. So while the statement was made in passing and doesn't form part of the judgment, it does give an indication that in relation to environmental offences, the reverse onus provision may not be as constitutionally suspect as it is in other situations. Moving on to supply chain, here's another example that was provided by Further Africa, which dealt with the floods in 2023 and 2024 in KwaZulu-Natal, which had a huge impact on rural and district roads, limiting access for milk collection trucks and disrupting logistics across the province. Because of this damage, farmers were unable to deliver milk on schedule, and because cows required milking every day or twice a day, many were forced to dispose of the milk, resulting in loss of income. Additionally, infrastructure such as dams, irrigation systems, center pivots, and pastures suffered damage, further stressing livestock and reducing feed availability. Downstream dairy producers were unable to maintain production schedules, threatening supply to retailers and to consumers, including vulnerable communities dependent on dairy as a primary source of essential nutrients. Considering the impacts of flooding risks affects not only your operations, but also your supply chain. Unmanaged water may lead to the deterioration of transport infrastructure, such as roads, as in the example that I've just provided. It also may delay in resources being delivered to your operations. The deterioration of resources themselves might also be a factor. So therefore, you might lose, for example, crops or important resources into your operations. The deterioration of a supplier's infrastructure, machinery, or resources, leading to interruptions in supply. In turn, this can impact your ability to comply with your legal obligations and undertakings under agreements, which could expose you to penalties and or possibly even losing contracts to competitors. We've worked with several clients in reviewing their supply agreements to strengthen their supply chain and reduce supply chain risk. And we think that this can be, or we know that this can be achieved in several ways through your supply contracts. One, you can impose obligations on suppliers to undertake climate risk assessments to identify climate risks in their business. This may include modeling of water, both the impacts arising from flooding as well as droughts or interruptions into the water supply. Two, you can impose obligations on suppliers to implement measures to reduce climate risks, such as building additional infrastructure and or assisting suppliers to implement these measures and obtain discounted charges as payment for your investment into their business. Three, requiring suppliers to regularly report on potential supply chain risks so that these impacts can be mitigated in a proactive way rather than in a reactive way. Four, providing favorable trading terms, such as quicker payments of invoices for those suppliers that implement climate resilient measures. Five, having flexible termination clauses in your supply contracts, which allows termination of contracts so that you can conclude contracts with parties that implement better climate risk measures. Six, setting objectives and targets on items such as water management and reporting and compliance with these objectives and targets. Seven, requiring similar supply chain clauses to be imposed into the supplier's supply chain contracts. 8, risk sharing and force majeure clauses so that you can mitigate or limit your risks for events that are outside of all the parties' controls. And 9, warranties and indemnities regarding infrastructure resilience. Taking a more proactive approach to supply chain contracting, particularly in light of climate change risks such as flooding, will reduce the supply chain and operational risks. Finally, I'm going to quickly touch on director liability. Again, and director liability in this context is being discussed outside of what I was speaking about under Section 28 of NEMA and the prosecution risk. So this is, and something which we're seeing a lot more commonly is director liability in relation to fiduciary duties under the Companies Act. So here we're looking at trying to enforce environmental objectives through the company legislation as opposed to strictly through an environmental legislation. The duty of care and incidents I mentioned earlier and the section on the supply chain risk management focus on the physical costs associated with extreme weather events like flooding. However, where these physical costs give rise to a failure to exercise a duty of care or comply with best practice, it can have a material impact on corporate value. So, for example, Vale's share price fell by about a quarter when its tailings dam in Brumadinho failed in, I think, 2019. As a result, managing risks associated with climate change is essential in generating shareholder value and thus squarely engages directors' fiduciary duties as well as their obligation to disclose and report these risks. The fiduciary duties of the director are partly codified in Section 76, 3A and B. I'll talk about paragraph C shortly. In relation to Section 76, 3A, the duty to act in good faith requires a director to act honestly and without the intention to deceive. It requires a director to act in a way that he or she genuinely believes to be in the best interests of the company. In assessing whether a person acted in good faith, the courts have adopted the reasonable man test. That is, would a reasonable person in the position of the director have done the same under the circumstances? If a reasonable director would not have acted in the same way as the director in question, then the director would not be considered to have acted in good faith. Whether the director acted with a proper purpose, on the other hand, is an objective assessment. Here, the court looks at the relevant company secretarial documents to determine the company's purpose and how the director's appointment was intended to further that purpose. If the director's conduct does not align with this purpose, he will have found to have acted without the requisite purpose. In respect of Section 76(3)(b), i.e., the acting in the best interests of the company, the director must act in its best interests, which includes acting in the best interests of the current and future shareholders without giving preference to any individual group of shareholders. When considering if a director acted in terms of Section 76, 3A and B within the climate context, guidance can be taken from the King Codes on Governance, which recognizes that environmental and social considerations must guide business decisions if these decisions are to create value in a sustainable way. The King IV guidance paper on climate change in this regard provides further insight. It states that governing bodies must ensure that business strategy and decision-making include a broader, integrated consideration of social and economic and environmental, including climate change, performance and impacts. This incorporates an assessment of externalities, as well as determining risks and opportunities for both the short and long term. Governing bodies should make every effort to mitigate their organization's contribution to climate change. It goes on to state that governing bodies must act in good faith and in the best interests of the organization. Such actions must go beyond mere legal compliance. Developing a response to climate change should not be based on only on requirements in applicable laws, but should result from the governing body ensuring that management strives to do the right thing for the organization, society, and the environment while promoting good governance. What constitutes the company's best interest must also align with what is contained in the Bill of Rights, which forms part of the South African Constitution, which includes the environmental right. This is a right to an environment that promotes the health and well-being of all persons and adopts the principle of sustainable development. That is, all decisions must take into account the social, economic, and environmental impacts of that decision. It is suggested by some academics that socially and environmentally responsible board decisions will benefit the company and shareholders in the long term. In this context, a director's failure to consider climate risks poses a foreseeable and material financial risk to the business for which reasonable steps must be taken, failing which the director may be found not to act in good faith and in the best interests of the company. To avoid that liability under Section 76(3)(b), a director would need to show that he took reasonable, diligent steps to be informed on the potential matter, in this case, the climate change and flooding risk. He has no potential or personal financial risk in the matter, and he had a reasonable and rational basis for believing that the decision that he or she took was in the best interests of the company. This is referred to as the business judgment rule, and it can only be applied in relation to 76(3)(b because this is an objective test as opposed to it is an objective test as opposed to the question of in 76(3)(a, where it is more of a subjective test. In the climate risk context, if a director obtains expert advice on climate risks, but then fails to adjust the operations of the business to incorporate this advice, he may be found liable. For example, water flood modeling indicates a risk to operations if certain measures are not taken and the director does not action these measures in favorable of short-term profits or commitments. If so, the director may be found to have acted irrationally. This defense is not available in relation to Section 76(3)(a) and B, and A, as I said, because of the objective test. In relation to Section 76(3)(c), this deals with the director's competence. That is, the director must exercise the degree of skill and diligence that is reasonably expected of a person having the general knowledge, skill, and experience of that director. Therefore, if the director is one that has ESG experience, he or she will be judged against a higher standard. Whether a director is held liable under this section is based on a partly objective test, but this does not mean that the directors can follow advice blindly. They must still exercise an element of due diligence, which involves inquiring into the risk. In a climate change context, a director may be held liable where the climate risk poses a foreseeable and material risk that was not considered adequately or at all, or they assess the climate risk but fail to exercise reasonable care, skill, and diligence in managing that risk. For example, they failed to allocate sufficient resources to assess a flooding risk, or failed to provide sufficient resources to the business to suitably mitigate that risk. From an internal governance perspective, it is therefore important for climate change risks to be communicated through the business to the board. This is done by ensuring that the appropriate reporting mechanisms are developed within the company and environmental matters form part of board packs. In relation to disclosure and reporting, Section 29(2) requires that financial statements must not be false or misleading in any material respect or incomplete. And Section 76(2)(b) states that a director must communicate to the board at the earliest practical opportunity information that comes to his or her attention. While these sections do not specifically relate to the director's obligations in respect of climate risks, they are phrased broadly enough to include these risks. This is confirmed when these sections are read in conjunction with the King Code, which contemplates that inter alia the governing boards should ensure that the organization is transparent about its response to climate change and disclose quantitative and qualitative information which could affect a stakeholder's decision in respect of the company. There are a range of possible or potential liability pathways under the Companies Act, environmental legislation, and the common law, which can be followed to impose liability on a directive. These are either through derivative claims or delictual claims, or under the environmental legislation itself. Given the time that we have for this presentation, and I think we are already running over, we will not delve into each of those potential pathways. In closing, there is evidence demonstrating that extreme weather events causes flooding and drought and increases the risk of which increases the risks to businesses. These events can impair or damage a company's infrastructure and supply chain, leading to commercial losses and ultimately to value of the business. In addition, it can cause harm to the environment, health and safety of employees and communities as well. There's a legal duty on companies and directors to take measures to assess the nature and extent of these risks, including the use of modeling technologies, and implement suitable mitigation measures to prevent or mitigate this harm. These mitigation measures may include physical changes to infrastructure and strengthening the supply chain risks. Failure to implement these measures may result in prosecution and damages claim. This is an ongoing obligation. Climate impacts are constantly evolving and changing, which requires companies and directors to continuously monitor these risks and adapt incrementally. Thank you.
Thank you, Matthew, for the insightful presentation. Just one question for you. Could municipalities also institute legal actions in terms of these offenses?
In terms of, So just, I suppose, just in terms of Section 28 of the National Environmental Management Act, the municipal manager is able to issue directives against third parties for failing to take appropriate measures to prevent environmental damage or degradation from occurring, continuing, or recurring. So that would be their mechanism to enforce compliance. And if as we've indicated in terms of Section 28, if the person to whom they issue that directive fails to take measures, then the municipality would be permitted to approach court and try and reclaim the costs from the various parties that we mentioned there. So those would be the parties who were negligent in preventing harm from occurring, or parties that, or from the landowner, or the parties that are responsible. So in short, yes, there would be mechanisms available to the municipalities in terms of the law to be able to enforce that. And then there would be mechanisms, should they suffer harm as a result of a failure to take measures, that they could pursue in terms of delictual law.
Okay. Thank you. Just to summarize what Matthew taught us today, which was very informative. Now we know that our infrastructure has to be properly modeled. We need to take proactive measures, make sure that our infrastructures are resilient enough so that they can sustain even the harsh climate change, the conditions, and also do like a bit of, also do more of due diligence when we're designing and everything, because there are actually risks associated with this. It might be like supply risk, climate, and even it might affect business and even all other things. So thank you for that, Matthew. We really learned a lot. And he also mentioned a lot about climate change and flooding in KZN. So we also have solutions for that, like things that can actually solve that problem, which is part of our authorized solutions and all these products here. When you model, when you take your project on site during construction, during operations, and even maintenance, we know that, okay, we can actually predict and we can actually make sure that we resolve those problems so that in future we don't have to have them. So if you ask me, how can we help you as Baker Bates? We solve our customers' problems through digital transformation. And you can also partner with us so that you can learn more about our water solutions. If you need analysis, you need training, or you need to implement something, you can let us know. And I'll just launch this poll now just to know if you need anything, like maybe you want to see a product demo, you need just consulting to know how does this work, maybe project assessment or discovery session. And we also have what we call Introduction to authorized Water Infrastructure Solutions. It's on our transformation tools. We'll drop this link for you so that you can read more about the solutions that can actually prevent all these risks that we have. And we also based in Joburg. Our offices are in Woodmead and another one in Cape Town. So if you ever need anything, please keep in touch with us. We also on YouTube, Instagram, Twitter, Facebook, and LinkedIn as well. So with what Matthew said and the whole of this webinar today, we know we have extreme weather events that are likely to become more intense and frequent. So I encourage every person who actually attended today that please, just know that it's your responsibility, it's my responsibility to make sure that we prevent things like pollutions from continuing, and we also model our designs properly, and we also manage our assets and infrastructure properly, because we don't want to have penalties and fine, right? I think Matthew said it's like 10 million or more. So have a great Friday. And if you ever have questions, please let us know. And sorry for taking longer. Thank you.